let's go on to maintenance court. Now, maintenance court has its empowering legislation, Maintenance Act, and the Maintenance Act has very, very specific provisions regarding which matters can be adjudicated by the maintenance court. Now, you can approach the court in terms of Section 6.1 of the Maintenance Act as its empowering provision in terms of the scenarios under which you can approach the maintenance court as a litigant or on behalf of a client being the litigant. And the complaints, the forms that they can take are really as follows. And I'll read briefly through the legislation and then I'll just go on to my next summary slide, which will help you to assimilate it quite nicely. Whenever a complaint that any person liable to maintain any other person fails to maintain the latter person, that's sub A. B, that good cause exists for the substitution or discharge of a maintenance order, or C, that good cause exists for the substitution or discharge of a verbal or written agreement in respect of maintenance obligations, in respect of which there is no existing maintenance order, has been made and is lodged with the maintenance officer in the prescribed manner. The maintenance officer shall investigate that complaint in the prescribed manner and as provided for in this act. And then, folks, you go all the way from your Section 6 all the way through to Section 10 during your maintenance court proceedings. So we have three scenarios envisaged in the Maintenance Act. Incidentally, just before I struck my little panic regarding the slides, those who want to start litigating in the maintenance court or want to understand maintenance court better, do start with Section 6 all the way through Section 10. It will give you a good idea of the functioning of the maintenance court, and then it makes it quite a bit easier to read the remainder of the legislation through the lens of that. Okay, I see Jonathan also says we're still on the maintenance court slide. So what I'm going to do, I'm just going to keep chatting to you folks. I'm just going to stop sharing and then reshare. Now, the three scenarios that we get in terms of maintenance court, firstly is the most obvious one. It's the one we see most frequently, and that is the scenario where a person legally liable to maintain another person fails to do so. Now, that legal liability to maintain makes it fairly broad. It opens up various cans of worms in terms of Children's Act, Maintenance Act, even potentially issues of spousal maintenance conceptually, if you are not being maintained by your spouse during the marriage. If there's no divorce proceedings, you can conceivably approach the maintenance court, although I haven't seen it happen in practice. That is scenario number one. My slides should be sorted now. Please, for those of you who are stuck on previous slides, please do use the arrows at the bottom and just follow along. Great, thanks for confirming, Corin. Right, scenario one is Section 6.1a. A person legally liable to maintain another person fails to do so. Vast majority of maintenance cases. Coming in second in terms of frequently encountered issues is scenario two. There is a maintenance order of some sort, either granted by a divorce court or granted by the maintenance court, but there is a maintenance order in place, in other words, a court order dealing with maintenance, and you want it discharged or you want it substituted or amended, in other words. That's Section 6.1b. Section 6.1c is an interesting one, folks, and I think this is one of those that really are that really don't get enough publicity, and that is substitution or discharge of a verbal or written agreement in respect of which there is no existing maintenance order. So a good example would be, let's say, mom and dad got together and they discussed and agreed by email, for example, that dad would contribute 5,000 Rand a month for the child. That arrangement goes on, never escalates. Now it's 3 years later. Mom cannot approach the maintenance court on the basis that he's legally liable to maintain and he has not done so, because he is maintaining. She cannot say there is a current order and I want it varied. No. What she can do, and this is obviously seen through the lens where mom would have reached out and tried to amicably get some sort of redress or discussion, and let's say for purposes of this scenario, dad refuses point blank, mom can then approach the maintenance court and attach the email saying, look, 3 years ago we agreed on 5,000. He's been paying 5,000. He's not maintaining. I'm simply saying the agreed upon quantum is not sufficient and I need a variation of this maintenance regime in respect of which there is no order. Right, let's move on to maintenance court process. As I said earlier, folks, Section 6, Section 7, Section 10 are your Bible when it comes to litigating in the maintenance court. First off, the applicant or complainant completes the application form for maintenance. They submit it at court. Now, if we talk about idiosyncratic tendencies of various courts, this Section 6 form that you complete is one of the ones which I've seen which is most often resultant in poor candidate attorneys running back to the office saying, go back to the drawing board, we need XYZ form. Some maintenance courts require a whole plethora of documentation. Other maintenance courts require sparse documentation, but if you are intending to launch a maintenance court proceeding, please be very, very careful to find out what your local court requires in terms of attached documentation. Once the matter has been referred to the maintenance court, an investigation by a maintenance officer or an MO will ensue. Maintenance officers are generally prosecutors working for the department, and they specialize as maintenance officers, and they would then really run the process together with the parties. Although the magistrate in a Section 10, which is a maintenance hearing or trial, makes the final maintenance order, preparing the matter for that trial, subpoenaing documents, facilitating the exchange of documents, facilitating the engagement between the parties, very often, in all cases, really falls within the auspices of the maintenance officer and their duties as a functionary of the court. Now I'm going to share with you the maintenance court forms, and what we're going to start with is a complaint in terms of Section 6.1a. Bonus points to those who can remember. A referral in terms of 6.1a is if someone who is liable to maintain another person is not doing so. So in other words, the form, the 6.1a form, the J101E, is the form that you complete if there is no maintenance being paid. This is a bit different in format. You start off with the name of the complainant, who is the person launching the proceedings, then who is the person defending the proceedings. Then you look at, is it for someone claiming on their own behalf, the defendant is legally liable to maintain me, or liable to maintain the children mentioned in 4 below, and you set out why they are liable to maintain. So defendant is legally liable to maintain me because, well, we're married and they are not maintaining me, and we have a reciprocal duty of support, stante matrimonia. Or the children mentioned in 4 below because the defendant is a biological parent and they are not, or they are a biological grandparent and the other parent and myself cannot support, and here is the reasons why we cannot support, etc. Then you say how long they have not been paying, since which date, or they have made no contribution or the following contributions. Now, this may look like it's the scenario of an agreement that was not made in order of court. If you guys all remember, I think it's the 61C, I think. We'll check now. We'll just check me. Not necessarily. It could be that this party has just paid whatever they think is reasonable. Then you ask in terms of what contribution you want to claim, when it should be made, which day, which account number, all payments to third parties you can set out there. And then, folks, this document is magic. Even as a back office document for clients, if you want to get a good idea of their financial position in terms of income and expenses, this contains a good rundown of the maintenance expenses. You'll see it is listed or it is divided between self and children. I'm not going to get into the 1/3, 2/3 debate here, but you would generally say this amount is for myself, this amount is for my children. In some cases, for example, lodging, that is an expense which affects both the children and the party. Whereas you get expenses, for example, let's say one of the children has a membership fee for a extramural activity or whatever the case may be. That would be solely for the child. Or if the parent is a member of an organization and the child is not, then it is solely for the parent. Always distinguish between three types of expenses: parents' expenses, children's expenses, and combined expenses. Right. And then this is signed under oath, and you accompany it with the supporting documentation which may be required by the court. Okay, that is an application for a maintenance order. Once again, as is the case with the Children's Court Form 2, you simply take this form to court and lodge it. The court takes it from there. Then, substitution of or discharge of an existing maintenance order. You'd set out who is launching the application for discharge, who is the person against who it was made, which court ordered it, and what was the order, and what do you want the order to be amended to. Or if you say that it must be discharged completely, you set out full reasons for it, and then once again you set out your monthly income and expenses. Obviously, please do not thumb suck here. If you are incapable of doing it yourself, refer to a professional who does these sorts of things. Just as a notable mention, I'm going to show you the maintenance consent order. This is what a consent order looks like in the maintenance court if the parties settle during the maintenance proceedings and they want to have a maintenance order made by consent. The parties would sign this, signature of the person against whom the order is going to be made, and the acceptance of the applicant. And then that is made an order of the maintenance court.